But we're just waiting for the other two.
Nee man, dat is... Gooi hem eens op.
Huh? How's the police?
Where's my security guards, please? I also need nowadays.
Detective against the police. Ons is bezig met een disciplinaire onderzoek bij die law school.
Bij die law school? Nee, ik wil je iets vertellen. Ik is
Yes.
Alida, kan ik ook als security guard? Ja, ik is serieus. Wat is dat voor mij?
Jij gaat even praten.
Ja, gaan dan. Ja, gaan.
Daai Kaba, nee. Dit heeft ek dus opgevok in daai borginstuk. Hy is...
Hoeveel keer het jy al verskyn daar dan?
Ons het 11 keer al verskyn. En nie een keer het ons vir 'n uitslag gevra nie. Hy elke keer vra vir 'n uitslag, vra vir 'n uitslag. Hy het so rondgefok, hy het nou maar probeer om na hierdie ding toe te gaan. En Vrydagmiddag toe begin hy argue. Maar is die swakste argument, die langdradigste argument op een. Toe besluit ek, sê ek vir een fok dit. Beteken die papiere op hom. Hallo.
You found out what's happening?
Well, they definitely have not responded at this point, so we will launch the urgent application. It will be under the normal thing to be issued before Thursday for hearing on next Tuesday. You know, it's not like the house is burning down. But I don't know. We'll see what they come up with today. I mean, it's. I think the Bar Council is also going to join. So we'll see.
I know why they're doing it. Well, because I know
Why?
they're trying to look at you online.
But what does it matter? So what? I again say so what? The only person that can claim privilege is him, and he's dead. It had nothing to do with his murder, you understand? So there's no nexus on that. And whatever else there is, they've got an affidavit from Johan at BK, and it's quite clear that the rest of it is it's inadmissible, and it's not the case is not that Phumlani was arrested by policemen and died in custody. Their case is he was kidnapped by the accused before caught and murdered. So again, it doesn't make. They must
It
do
just
it.
makes sense now how they're trying to
Morning.
say that you
I thought you went away for the weekend.
Well, if they're going to do that,
You went away for a weekend. You've not been here.
good. Liz, how are you? Good.
Morning.
morning.
Good. We'll chat later.
Yeah. No, but I mean, if that's their ground, they even fucking further in
The judgment.
Yes, please, the court, my lord, call the matter case number 44 of 2014 State versus Radovan Krejcir and 5 others. We are ready to proceed today being the 24th of August 2015. The court appearance is as in before. We are ready to proceed.
I indicated that I might require additional argument. I've received additional argument from the various counsel in written form and do currently not require any further argument, and I'm accordingly in the position to deliver the judgment. The judgment has been prepared in writing. It is ever customary to read the judgment in court in criminal matters. The 6 accused are charged with 3 counts. Count 1 is a charge of contravening Section 5B of the Drugs and Drug Trafficking Act, in that the accused dealt in an undesirable dependence-producing substance. Accused 1 and 2 are an alternative to count 1, also charged with possession of the substance. The accused are charged in count 2 with kidnapping 1 Becky Temba Lukele on 25th June 2013 and holding him over the period 25 June 2013 until 29 June 2013. The accused are further charged with count 3 that they attempted the murder of Lukele. The accused all pleaded not guilty to all counts. The claim made was that accused 2, acting in concert with accused 1, had given one doctor a bag containing 25 kilograms of ice, tip, or crystal meth drugs to enable him to export same. He had, in breach of the arrangement, taken the bag of drugs for himself. Accused 1 and 2 were urgently trying to recover their drugs from him and decided to capture Lukele, doctor's brother, and use him to find doctor or at least blackmail doctor to deal with them and return the drugs to them. In the course of the activities to seek to find doctor and recover the drugs, accused 1 and 2 had made use of the services of accused 3, 4, 5, and 6. Boiling water had been poured over Lukele, and he had been kicked, punched, and manhandled during the time he was held captive. The version of the accused, who all gave evidence, was that they had been involved in neither kidnapping nor assault, nor dealings in relation to a bag of drugs. Accused 2's evidence, in addition, was that at or about the time of the abduction of Lukele, and for a day or 2 thereafter, he had been urgently seeking Lukele's brother. The reason why he was seeking the brother was because the brother owed him money which accused 2 wished to be repaid. A convenient point at which to begin a consideration of the matter is the kidnapping of Lukele. The evidence of Lukele was that he was at home at about 8:20 in the evening of 25th June 2013. He heard a knocking at the gate. He looked through the window and saw people outside. He went to the gate. The people who were there asked him where his brother was. His brother is doctor. Lukele stated that his brother was not at home. One of the people showed him an identity card. The person who showed him the card said he wanted to speak to his grandmother. Lukele opened the gate to allow them into the yard. They asked him when he had last seen his brother. He replied it had been some days since he had last seen him. The people knew that this was not true. They interrogated him to try to get him to concede that he had been at a shopping mall with his brother much more recently than he claimed. He was grabbed, manhandled, and stabbed. There were about 6 people who'd come in 3 different motor cars. a white BMW, a Vita, Mercedes-Benz, and a 4x4 of a dark color. Lekele was forced into the BMW, his shirt was used to cover his face, and he was told to look down. His hands were tied behind his back with a paddle tie. According to an affidavit contained in a docket handed in by the accused, the fact that Lekele was put into a car by a group of men was witnessed by Lekele's neighbor, one Ncube. Ncube, on 29 June 2013 at 1400 bracket, prior to the release of Lekele close bracket, laid a charge that Lekele had been kidnapped. He made an affidavit at 11:45 that day, setting out that Lekele had been kidnapped by a group of men in a vehicle which he believed to be a Toyota, the registration number of which he provided. Pursuant to this charge being laid, a docket was opened. That docket bore case number 303/6/2013. Ncube was not called as a witness. Although the docket was produced in evidence by the accused, it contains the hearsay statement set out above. The evidence about the incident is inadmissible to establish its truth. The fact that at the time when the docket concerning the incident at Lekele's residence is admissible, however, those facts establish that prior to the release of Lekele, a charge that he had been kidnapped had been laid. This is corroborative of Lekele's evidence that he was in fact kidnapped. Lekele said that the reason given by his captives for capturing him was that the doctor had taken their money. After he was put in the BMW, Lekele was taken to a house. In an office in the house, there were a number of people present. He was manhandled, kicked, slapped, and punched. He was also threatened by a white person. The purpose of the interrogation was to find out where his brother was. During the course of the interrogation, Lekele was forced to sit on the floor facing a corner. One of the persons attacking him spoke in English and said that Lekele's brother had robbed him of money and that he wanted the brother as well as the money. The blindfold over Lekele's eyes was removed by a person later identified as accused father Peter. The person who had spoken asked Lekele if he could see him and was asked to look at his attacker. He was also asked whether he knew his attacker and whether he was prepared to die like a soldier. Lekele said that he could see him. The person asked where Lekele's brother was. Lekele did not finish the answer. The person who asked the question poured boiling water over his head. Lekele was able to identify the person who poured the water over him as accused one. Lekele suffered injuries including blistering of the skin in consequence of boiling water being poured over his head. He was subsequently kept in a safe house. He was at a point taken to Ermelo to find his brother. Apart from that trip, he was kept in the safe house until his release some days later, on 29 June 2013. The details of these events are dealt with more fully below. On 30th June 2013, he went to the doctor. The doctor, Dr. Nkosi, recorded his observations as follows, open inverted commas, burn wound in brackets, primary, close inverted commas. The doctor prescribed treatment and required his patient to return after 2 weeks. All of this appears from Exhibit B. The Form J88 was completed not by the treating doctor, Dr. Nkosi, but by Dr. Nkandla. That form reveals as a general history that the patient had come with a history of being burnt by boiling water being poured on his head, the left side of his face and left chest. The form indicates that there was a primary first-degree burn wound over the head and left side of the face and cheek. The picture on the form was completed and showed markings intended to indicate the places where the injuries were situated on the left side of the head and face and the top of the left side of the head. These markings were not made by the treating doctor. On 20th May 2014, during the trial, Lekele was examined and a report prepared and handed in as Exhibit H. That report revealed that Lekele evidenced scars of year-old burn wounds, including a big scar on the right shoulder and scapula, small scar on the left shoulder, and a scar on his left cheek. Markings were made on page 4 of a different J88 reflecting the situation of the scarring. That examination was made and the findings written in the absence of defense counsel. Defense counsel wished to examine Bukele to ascertain whether or not the findings made were accurate. In order for this examination to take place in a dignified manner, Bukele, by consent of all, was taken to Dr. Mia, who filed a report, Exhibit P. The findings contained in the report became part cause. They showed hyperpigmented lesions over the shoulders bilaterally extending anteriorly onto the clavicles. They were also bilaterally visible over the scapulae and the right shoulder. The lesions were flat and had a geographical nature. A left clavicular hyperpigmented area was noted as well. In addition, the right forearm evidenced an old scar and skin grafts. These skin grafts and scar antedate the kidnapping and are irrelevant for present purposes. The left hand had also been injured and showed hyperpigmented areas on some of the fingers. The doctor's conclusion was, in inverted commas, hyperpigmented old scars with geographical pattern over left preclavicular area, face, bilateral shoulder and scapular areas and over clavicles, consistent with but not exclusive to history of 11-month-old burn wound, closing inverted commas. Page 4 of the J88 was completed and reflects where the injuries were seen. The injuries were seen and the examination conducted by the doctor who was an expert in the field. These injuries were essentially common cause and reflect the condition of Bukele at the time of the trial. The opinion of the treating doctor was not of the examining doctor was not challenged by anyone. Bukele stated that he had not suffered any other relevant injuries. The only source of the remaining injuries, beyond doubt, is the pouring of boiling water over him about 11 months before the examination. 11 months before the examination is the time when Bukele was kidnapped. The doctor who treated Bukele, Dr. Nkosi, gave evidence and made light of his injuries, stating that from his notes there would only have been a redness of the skin and not a blistering. This evidence is not in line with his treatment of Bukele. He prescribed diclofenac, Ferox, Savlon, and Emirate drugs to deal with sepsis and pain. The objectively ascertainable facts establish that there is pigmentation of the skin caused by damage to it. Various state witnesses, including Bukele, described blistering. Even on the treating doctor's evidence, there was evidence of burning of the skin. His issue related only to the severity. It appears to me that he was attempting to explain away the inadequate attention that he had given his patient. There would have been no sepsis to treat without open wounds. The only open wounds referred to by the witness are caused by the burn. Hence, Bukele had open wounds when seen by Dr. Nkosi. In my view, beyond reasonable doubt, there was blistering, and such blistering left the hyperpigmented areas seen by the examining doctors. The fact that a charge concerning the kidnapping, the fact that a charge concerning the kidnapping was made prior to the release of Bukele is corroborative of the fact that he was kidnapping. There is evidence of his having been burnt and sustaining injuries consisting of the burn emanating from boiling water being poured over him. He did not burn himself. Someone burned him. Bukele went to consult the doctor the day after his release at the first reasonable opportunity. The only inference is that he was in sufficient pain to require treatment. The only inference to be drawn from these facts further is that he was kidnapped and that while he was in the control of his kidnapper, he was burned by boiling water being poured over him. These facts, in my view, establish beyond reasonable doubt that Bukele was kidnapped on 23rd June 2013 and that he was assaulted by the pouring of boiling water over him. The duration of the kidnapping can be determined with reference to Bukele's conduct as well as his ipso dixit. Bukele stated he was held until 29 June 2013. The fact that he was so held is corroborated by the fact that at the first reasonable opportunity, when he could go to seek treatment, 30th June 2013, he did so. I accordingly find that Lekele was held from 25 June 2013 until 29 June 2013. I accept Lekele's evidence that he was kidnapped, held over the period, slapped, manhandled, kicked, punched and burnt as is stated in his evidence. A number of criticisms were made of Lekele's evidence. Lekele, in his statement, did not distinguish between being held at the place where the assault took place and at a safe house. He was severely criticized for this. This criticism is dependent upon whether the statement was taken accurately by a person who asked the right questions to get the whole story accurately. The police investigation in this matter will be dealt with later. For present purposes, it is necessary only to note that 3 attempts were made to get Lekele's statement, and the result remains a poor effort. In my view, all the statements were taken in a slapdash way without proper attention to the facts they needed to cover. Hence, there are multiple omissions and apparent inconsistencies in them. In addition, a statement is generally a précis of facts, and one should expect omissions when the larger picture is pieced together and produced in evidence. Lekele in his evidence before me indicated that he had originally been assaulted at an office and in a house, and had subsequently been kept in a different house. I accept this evidence of his. It is supported by the evidence of the other witnesses with whom I shall deal later. Importantly, it is also supported by the cell phone records of Peter Nsimanga, bracket Peter, close bracket, which indicated that he had spent time in Kensington near where the safe house was situated and where he said he had guarded Lekele. These records corroborate that Peter was with Lekele on the day and at the place he said that he was requested to guard Lekele. The offices of Money Point are situated within a house. Lekele correctly identified the place where he was initially held as being a house. The probabilities favour that Lekele would not have been detained in the office at Money Point during working hours and overnight, but would rather have been kept elsewhere. The explanation for the apparent discrepancy as to where Lekele was kept is in the poor statement taking of the police, in my view. Who would want to kidnap Lekele? It is apparent from the evidence of Lekele that there was no person looking to kidnap him, and that there wasn't any reason why he should be taken and held captive, never mind be assaulted. During the course of being held captive, he was taken to Ermelo. There was no reason why on his own he would go there. Lekele provided a reason for his being kidnapped, assaulted, detained and transported to Ermelo. The reason was that the person who had done these things was seeking his brother Doctor. That person sought to find Doctor by forcing Lekele to disclose his whereabouts and or blackmailing Doctor into handing himself over to secure the release of Lekele. The evidence of accused 2 was that he was looking for Doctor and that at the material time he made use of Peter and Paul to help him look for Doctor. Peter and Paul corroborated those facts. Accused 2 said that he did not kidnap Doctor's brother and further that he was not looking for drugs but for money. This evidence will be dealt with in more detail as the story unfolds. The inference is irresistible that the only person conducting a search which in any way was linked to Lekele is accused 2. The state witnesses describe accused 2 as being the person who was involved. It is common cause that accused 2 at the relevant time was seeking Doctor and that search for Doctor was urgent. Accused 2 on his evidence owed money to his creditor which he was unable to pay easily, as that money had been lent to Doctor and Doctor had not repaid it to him. Accused 2 sought corroboration for the fact that he was looking for Doctor for money which had not been paid. In the evidence of Lekele, he said that he was told that his brother Doctor was being hunted in order to obtain money which had been given him. The only person hunting anyone, whether for money or drugs at that time, was accused 2. The inference that accused 2 was the hunter is irresistible, and I so find. The fact that Lekele said that the kidnappers were looking for money corroborates only that is what he had been told. It was accused 2 who implemented, together with others, the steps taken to kidnap Lekele. The kidnapping of Lekele was designed to flush out Doctor. Accused 2 and others went to Ermelo where Doctor was believed to be. They took Lekele with them to help find Doctor once they were there. The fact this trip was undertaken further links the kidnapping of Lekele to a hunt for Doctor. The only person wishing to flush Doctor out was accused 2 on his own version. The evidence was that he was present at the time that boiling water was poured over the head of Lekele. I accept that evidence and accordingly find that accused 2 was a participant in respect of that incident too. Why hunt Doctor? The courier, Doctor, convincingly describes the plan to export drugs and its implementation. The extent of the search of the facilities, including the employment of Peter, Paul and sundry policemen used, indicate that the hunt was for something of a significant value. Accused 2's evidence was that a large sum of money changed hands. The evidence of the state witness concerns a lot of money changing hands. Accused 2 has a different causa for the money changing hands. He said it was a loan to Doctor. He needed the money back to pay his creditor. The reason why suddenly on the Monday the matter became urgent is on accused 2's version unexplained. When was he being pressed for payment? When was he to make actual payment? Why could he not get terms, as he appears ultimately to have easily been able to manage? After a few days of searching for Lekele, accused 2 gave up. There was no reason on his evidence to suddenly stop a very extensive and expensive hunt. The reason for stopping the search is much more likely to be because he believed at the time the bag of drugs was irrecoverable. It is impossible that being forced to pay any amount to his creditor would at a point make the matter urgent for accused 2, and that it would become less urgent once he had actually paid the creditor out of his own money. It is much more probable that if accused 2 was forced to pay his own money, he would redouble his efforts to find Lekele. The evidence of accused 2 on this issue is unacceptable and I reject it. The evidence of all the state witnesses was that a considerable quantity of drugs which accused 2 had given Doctor was the subject of the search. Accused 2 was hunting Doctor to retrieve the bag of drugs. In the course of that hunt, accused 2 kidnapped Lekele and was a party to the assault upon him. Who else kidnapped Lekele and Lekele's version evidence? After his capture and during the interrogation, boiling water was poured over Lekele. Immediately prior to the boiling water being poured over Lekele, a white person indicated to Lekele that he, Lekele, should look at him. He had previously been told to look down and had had his eyes covered. However, when he was asked to look at the person, he did so. He looked long enough to be able to identify accused 1 as being that person. He was forced to look at the person, saw the kettle in his hand and then the water. No one's going anywhere. It was submitted that the identification of accused 1 constituted a doc identification and was unreliable. Lekele was certain who he had seen. He had looked in response to being asked to do so. It appears to me that in the circumstances there is no reason why his looking should not be accurate. He was specifically inspecting accused 1 for a period of time in response to accused 1's request. His identification of accused 1 as the perpetrator of the act of pouring boiling water on him is also corroborated by other witnesses. In addition, the events, according to the evidence of the other witnesses, took place at Money Point, a place frequented by number 1. In the light of these facts, witness evidence and the fact that Lekele was taken to Money Point, the identification by Lekele of accused 1 as a participant in the kidnapping and the perpetrator of the assault constituted by pouring boiling water over him is established beyond reasonable doubt. Lekele identified accused 4 as being one of the persons who kidnapped him from his home on the evening of 25th June 2013. He identified accused 4 as being the person who had come and had worn the lumberjacket. He described certain physical features of accused 4 and said that he had seen him and was able to identify him properly He had seen him over a period of time and had interacted with him. Paul identifies accused 4 as being the person who was in the Vita at the time that the party of hunters went to Ermelo with Bekele with a view to finding Doctor. He went to the Vita when accused 3 was unable to open the car door as he was using the incorrect key. At that time, the original travelers in the car, which included accused 4, had returned to it. The submission was made that he had not expressly said that accused 4 had returned to the car. It is apparent from the evidence of Paul, however, that the persons who had been in the car were there and that there were no others. Accused 4 was present at the car. The identification by Lukele was challenged as being a doc identification made by a witness who had a limited opportunity to see the accused. Lukele was accurate in his identification. He identified 4 as a policeman. He identified him as the person wearing the lumber jacket, which was never denied. The fact that Paul saw accused 4 participating in the activities involving the hunting down of Doctor, of which the kidnapping of Lukele was a part, corroborates the evidence of Lukele. There are inconsistencies within the evidence of Lukele itself, and both as given to court and as against the statements made within the 3 statements taken from it. These inconsistencies and conflicts are mainly constituted by omissions and pale into insignificance when the major probabilities of the case which I've set out above are considered. It appears to me that a number of statements were taken from him by the police who had no understanding of the issues, how to take a statement, or what the adequacy of the statements was. I do not accept that the conflicts between the evidence and the matters contained within the statements demonstrate recent fabrication or a change of version on the part of Lukele. I consider that any inaccuracies and inadequacies are a consequence of the statements not having been adequately taken, and that they do not properly reflect what Lukele intended to state. Accordingly, on the evidence of Lukele, the identification of 1, 2, and 4 as participants is established beyond reasonable doubt. The drug dealers. It is convenient now to consider the matter from the perspective of Lukele's brother, Doctor, and his co-worker, Bekizita Kumala Subaba. This will introduce the early stages and set the stage for the events which subsequently took place. Doctor's evidence was that in 2012 he had met accused 2. The doctor worked as a supervisor in the baggage section at the airport. Accused 2 suggested that Doctor could assist with the dispatch of a parcel to Australia. Accused 2 said he was involved with a white person who would make their lives change. The assistance related to the export illegally of drugs. They would test whether it was possible to export the drugs. They did so, and one of the dummy runs at least was successful in that a 5-kilogram quantity of drugs was successfully exported during May 2013. Doctor was paid money for his work. This money was only a part payment of the full amount due to him. In June 2013, during the first week, Doctor and accused 2 met. By then, 2 had not paid Doctor the balance outstanding in respect of the previous dummy run. Doctor was disgruntled as he was working and being involved but not receiving the payment which he was supposed to have received. Later, accused 2 made an arrangement to bring a bag to Doctor on a particular Saturday. Doctor was working a morning shift. Doctor decided that he would not export the bag to Australia as he had agreed, but would rather sell it himself. He made arrangements that once he had the bag, he would sell it to one Morris. On 22nd June 2013, accused 2 brought Doctor the bag of drugs he was to export to Australia. Doctor took the bag from accused 2's car and put it in the car of Subaba. Accused 2 left. Doctor and Subaba drove off, and Doctor shortly thereafter handed over the bag to Morris. They all went to Benoni. At the house to which they went, the bag was opened by Morris. There were small parcels inside, There were small parcels inside, roundish in shape, and wrapped in silver tape. In all, there were 25 parcels shaped like a fist inside the bag. These 25 parcels had previously been described by accused 2 as being the drugs which were to be exported to Australia. Morris said that he would find a buyer, but he did not know what the things in the bag were. The doctor naively believed the things in the bag to be ice, meaning frozen water. He did not want to take the little parcels with him in case they melted. This belief of Doctor can only have arisen because he had been told they were ice. The next morning, accused 2 came to Doctor's house. He asked what had happened to the bag. Doctor explained that he had been searched by police who had taken the money which he had in his possession as well as the bag. Accused 2 did not believe him. Accused 2 spoke to someone on the phone and handed it thereafter to Doctor, saying that a white man wanted to talk to him. Doctor was told he should sort the matter out as the hawks from Pretoria had been to the airport and had said that no one had been arrested. Accused 2 said the thing should be sorted out before it got rough. Accused 2 took Doctor to the airport. Doctor stayed there until it was time to go home. He and Sababa then left and went to Tembisa. On the Monday, Doctor went to work. Accused 2 phoned to have a meeting. Doctor was told that the failure of the drugs to arrive and the loss of the drugs affected many people. They arranged to meet at a garage in Tembisa. Doctor spoke to Morris, who said the best he could raise for the parcels was 100,000 rand. Later there was a meeting between accused 2 and 2 others he had brought with him, bracket. We now know those 2 to be Peter and Paul, close bracket. Sababa, Doctor, and 3 brothers at the garage. Accused 2 and the 2 others had come in a combi. Accused 2 told Doctor that a white man wanted to see Doctor and that he should agree to a lie detector test. Doctor refused. They separated. Doctor at the garage spoke to a man, Morris, who was in the Navara. He received a payment from Morris. He followed the Navara and unbeknown to him was followed by accused 2 Peter and Paul. On the way the Navara stopped and they also stopped. Accused 2 Peter and Paul, fearing detection, drove on. This meeting and the following of Doctor is described by accused 2 Peter Paul, Doctor and Sabala. The only issue is what happened at the meeting. The probabilities favour that the discussion concerned the meeting, that the discussion concerned the missing drugs as the state witnesses described. Later, Doctor told his brother Lekele to meet him at the morgue. He told Lekele that he thought that he should hide for a bit as he had done something which could get his family and the brothers into trouble. Doctor went to Ermelo. That evening, Lekele phoned Doctor and said there were people in the yard. When he tried to phone him again, he could not get through, so he phoned the neighbour and asked the neighbour to see what was happening. That neighbour must have been Mlobo. Mlobo spoke to Doctor and gave him various information, including the registration number of the car and its colour. Doctor saved the information. Subsequently that night he received a phone call from Lekele. Lekele, however, did not speak to him. It was someone else. He was told that he thought he was being clever, and he heard the voice of his brother Lekele saying that Lekele's life was in his hands. This evidence is corroborated by Lekele, who described such a cycle taking place. According to the evidence of Peter, this call took place and was made from Lekele's phone in the presence of accused 5, who, on Peter's evidence, was the person who spoke to Doctor. The evidence of Doctor is corroborated by the other state witnesses and in part by the evidence of accused 2. Deputy Zika Somalo, who is known as Sababa, gave evidence. He was with Doctor when the bag of drugs was handed over. He did not know the person who handed the bag to him, to Doctor, and did not interact with him. After the bag was handed over, they drove away, and the bag was handed by Doctor to a man in the Navara. He and Doctor followed the Navara In due course, the bag was opened. It contained little parcels wrapped in plastic, which was silver grey in colour. There were 25 of them. He did not know what was inside the parcels. During the night, he was phoned by a person not known to him. That person asked to meet him. He agreed to meet the person at an engine garage in Sam Issa. The person turned out to be accused 2. Accused 2 asked what had happened to the bag and explained he was having difficulty making contact with Doctor. Sababa said he did not wish to be involved and that accused 2 should speak to Doctor. The next day, while he was at work, he got a phone call from Doctor who told him that the person who had given him the bag had come to his house to try and find the bag. He said that he had told accused 2 that the police had the bag. Sababa spoke to accused 2 on Doctor's behalf. Accused 2 said he wanted to see the 2 of them to get an explanation about the bag. Accused 2 informed him the owner of the bag was looking for it and that it was not his, accused 2's bag. They agreed to meet at Sam Issa at the garage. At the meeting, Doctor reiterated the bag had been taken by the police. Accused 2 said that it was one's bag and that he was demanding that it be returned. He said further that accused 1 was fighting with accused 2. While they were together, accused 2 phoned someone and gave the phone to Doctor to speak to that person. The time he handed over the phone, 2 said, "Here is Radovan Krejcir. Doctor, speak to him." Doctor spoke to the person and an argument ensued over the phone. The next day, Doctor spoke to Sababa and told him that he could not sleep as accused 2 had been phoning him continuously trying to organize a meeting. They agreed to meet. Sababa asked his 3 brothers to come with him. They were to meet at a garage in Telstra. When they arrived at the meeting, 3 people came to the vehicle. 2 were unknown, 1 was accused 2. Accused 2 said they should go to Bedford View so a machine could check whether they were telling the truth. They refused. While they were at that place, Doctor went to a white Navara and spoke to the occupant. When he returned, he said they should follow the white Navara, which they did. Eventually, a plastic bag containing money was handed over. The bag was said to amount the money was said to amount to Rand 100,000. His Sababa had already been given Rand 10,000 for the transport which he had provided to Doctor. That is the last he knew of the matter. His evidence corroborated the evidence of Doctor. His statement was put to him at length. There were discrepancies of a minor nature between the statement and his evidence. In my view, the witnesses with whose evidence I dealt, namely Lekela, Doctor and Sababa, were honest witnesses, told the truth and are credible. Their evidence accords with the probabilities that is reliable. The plan to export. The evidence of Doctor establishes vividly that after a successful dummy running, the arrangement was made to export drugs. The arrangement was made with him by accused 2 who delivered the drugs to him. He did not know if the drugs were actually drugs as he did not check the contents of the parcel, but he was told by accused 2 that they were in fact drugs. He, beyond reasonable doubt, was told the parcels contained ice. This is what he believed to be in the parcels. He patently had no idea that ice is a type of drug and does not have the characteristics of frozen water. The only person who could have told him the parcel contained ice is accused 2. Doctor explained how he had intended to export the drugs and how the drugs comprising the dummy run had in fact been exported. He had found a weakness in the system which he was able to manipulate to get the drugs aboard an aircraft. That system involved generating and attaching a label to the baggage and then pretending it was baggage which had been left behind by a passenger already flown out who was imminently due to fly out. It is not clear whether the Doctor discovered the weakness in the system before or after he met with accused 2 to arrange for the transport of the drugs. It is probable that he, having discovered the weakness, would manipulate it to his benefit. This lends credence to the fact that there would be a test run to check whether the weakness he had found would actually prove successful when manipulated and would be followed by a real shipment if the dummy run in fact proved successful. In my view, it is improbable that Doctor would have dreamed up the detail he provided about how the plan could be implemented and how he in fact came to implement it. The hunters. Peter Msimang indicated that he had received a phone call from a friend of his, one Paul. Paul had asked him if he could see him immediately, and arrangements were made to meet at Eastgate. When Peter arrived at Eastgate, he found Paul in the company of two. Accused two was a person unknown to him. Paul, in the presence of two, explained that a friend of accused two had taken a bag containing 25 kilograms of crystal meth, also known as tip. This person was known as Doctor, who was employed at the airport and who lived in Katloro. Paul asked whether Peter would be able to help recover the bag as he knew his way around Katloro. The assistance which Peter would provide would be to go with Paul to Doctor's home and act as backup. In return, he would receive 2 kilograms of the tip if it was found. Accused two, Paul and Peter, in Peter's car, drove to Doctor's home. They drove past the house, which was pointed out by accused two as they drove past. Accused two explained that the bag had been given to Doctor and one Sababa on a Saturday. At the time the bag had been given to Doctor, money had also been given as part payment for the transportation of the bag to Australia. All in all, Doctor would receive in the order of 250,000 rand to 300,000 rand. Accused two said that prior to handing the bag over to Doctor, there had been a meeting between himself, accused one, and Doctor. After the meeting, and unbeknownst to Doctor had been followed back home, so accused knew where he lived. A previous consignment had been sent using Doctor's services. The consignment was approximately 5 kilograms and had been successfully exported. By reason of the success of the first conveyance, the second conveyance, the current one, was increased to 25 kilograms. While they were in the car in the immediate vicinity of Doctor's home, two asked Peter to go to Doctor's house and see if he was there. Peter went to the Doctor's home and met with his grandmother. She told him that Doctor had left with the younger brother. Peter told accused two and Paul this. When Peter had entered Doctor's home, he told the grandmother that he was Jeff, using a false name. While they were in the car, two phoned Doctor and spoke to him. He asked Doctor where he was, and arrangements were made to meet. Peter, accused two, and Paul went and waited for Doctor, who did not come. Accused two phoned Doctor, who said they should meet at about 6 o'clock. Peter told accused two and Paul that Doctor was playing. He believed it unlikely they would see Doctor at 6 o'clock. This notwithstanding, they waited for him. Accused two telephoned Doctor again, and they were directed to a white minibus, which he was told to meet at a garage. They found the vehicle. Inside the vehicle were 5 men unknown to Peter. Doctor came out. When he came out, he was speaking on the phone, giving a person direction. The person to whom directions had been given came. In brackets, this person must be Morris. Doctor spoke to him, then returned to accused two, Peter and Paul. Accused two spoke to Doctor, telling him that the boss was looking for him, as he understood that the bag was lost. Doctor should come with them to take a lie detector test. During the discussions, a person known as Sababa stopped accused two and asked who Peter, accused two, and Paul were. He was assured they were friends. The doctor indicated during the discussion that he had no guarantees that he would return alive if he went with him, and he refused to do so. The doctor said that while he would not go and see the boss, he would meet Peter, accused two, and Paul the next day. Accused two explained to Peter that the boss is accused one. They observed Doctor and the people he was with for a while, but decided that they'd become aware of the fact they were under surveillance and left. They returned to Eastgate. Accused two telephoned the boss, accused one. He said that he had found Doctor, who refused to undergo a lie detector test. Accused 2 told accused 1 that doctor had said that the bag had been confiscated by the police and been impounded. He also told him they would meet again the next day. Peter said he had a problem and needed money, which accused 2 gave him. The next day, accused 2, Paul and Peter met at Eastgate. They decided to use Paul's Mercedes Benz. They went to Telstra. On the way, accused 2 phoned doctor, but was unable to speak to him as his phone was off. Eventually, they spoke to him. Accused 2 told Peter that doctor was evasive and would not meet the deal with him. The vehicle they were in developed a mechanical problem which they stopped to attend to. At this stage, accused 2 said that accused 1 had said they should kidnap the youngster who was a member of doctor's family. Peter asked 2 how this could be achieved. 2 said that 1 had said that he would send his own police to do the work. Paul left and accused 2 and Peter continued to wait. They waited at the filling station outside of Debonair's. While they were waiting there, a white BMW 535 came. Accused 2 told Peter that these are the boss's boys. He added they would wait for the boss himself. After a short while, accused 1 arrived in a white Mercedes Benz. 2 called Peter over and introduced him to accused 1 as the boss. Peter recognized 1 as he had seen him previously on television. The lighting was good. 2 said he is Radovan. After the introduction, Peter had left them alone. After a while, 1 drove away. He did not hear the discussion between 1 and 2. The discussion was relayed to him by 2, who said they should wait as the police were on their way. Doctor would get a message that accused 1 and accused 2 were no longer playing games. The police came in a Ford Focus sedan, maroon in color. Peter was only able to recognize accused 3 amongst the persons who arrived. Peter did not wish to participate in the kidnapping, and for this reason, he went to Eastgate, leaving the others to attend to the kidnapping. After he returned to Eastgate, he was told by accused 2 that they had kidnapped the young man and that he should go to the office. The office was situated at Money Point near Eastgate. When Peter got to the office, he found many people there. Accused 1, accused 2, 1 Johnny, 1 Ronnie, and the person who had been kidnapped. Of the people who were present in court were accused 1, accused 2, accused 5, and accused 6. In addition, Lukele was there. This was the first time Peter had met accused 5, 6, and Lukele. Lukele was facing a corner, sitting on the floor. His hands were bound behind his back. His head and face were covered with a hat. The persons present asked him questions. He said he had last seen doctors 2 days previously. It was, however, known that he had seen doctor much later than that, and he was confronted with the fact that Peter had been to doctor's home and knew this. Lukele was told that he was telling lies. He was kicked by Ronnie, accused 6, Kanyisa, and others. He was also slapped. Lukele asked if he could phone doctor. At a point in time, accused 5 took the blindfold off Lukele. Accused 1 said to Lukele, "I want you to look at me. Do you know me? Why are you lying? You were with him in the day. Are you prepared to die like a soldier? That is fine." As is apparent from what accused 1 said, he knew facts which had been obtained from Lukele's grandmother. Accused 1 brought a kettle which contained boiling water and poured it over the top of Lukele's head. Lukele experienced excruciating pain and screamed. He had blisters on his skin. Lukele asked if he could phone doctor. Accused 1 said they should leave the premises to enable the phone call to be made, and that the phone should not be assembled until they were well away from the premises. Peter, accused 2, accused 5, Kanyiso, and Lukele left to enable the phone call to take place. When they were far from Money Point, the phone was assembled. Lukele telephoned doctor and told him that his life was in his hands. He told doctor to return whatever he had taken, for if he died, it would be because of doctor. Accused 5 took the phone and said he was Sbu. He said that doctor should make things easy by returning the goods he had taken so that Lukele could be set free. The response of doctor was that he had been provoked and that it was a serious matter for which they could be arrested. Doctor further said that he would come the next day. Accused 5 suggested they should meet immediately and deal with the matter. Doctor told accused 5 that he could only come the next day. It was agreed they'd meet the next day, and the phone was then taken apart. They returned to Money Point, and what had happened was explained to accused 1. Accused 1 said that Lukele should be taken to a house. He was taken to this house, which was empty. Accused 2 opened the house. Lukele was left in the house guarded by accused 2. He was offered a box to lie on so that he did not have to lie on the floor. Accused 5 gave accused 2 a handgun to arm himself so as to properly guard Lukele. Accused 2 told Peter to come the next morning to relieve him. The next morning, accused 2 telephoned Peter. He was told to fetch Paul. Paul did not know where the house was, so Peter would have to fetch him and take him to the house. Peter went to Eastgate, met Paul. They went to the house where they found accused 2. Accused 2 left in Paul's vehicle, leaving Paul at the house. Peter went home. At noon that day, Peter met 2 and Paul at Eastgate. They all went to Money Point. The persons at Money Point included Peter, Paul, accused 2 and accused 5. When Mike arrived and said that he had found a number of the police, when Mike arrived and said he had found a member of the police who would be able to trace Doctor using a cell phone. It was established that Doctor was in Davidson at his wife's house. Paul, accused 2, accused 5 and Kanyisa went to look for Doctor. He was not there. The next morning they heard Doctor was in Ermelo. Accused 1 who was present said they should get Lukele to explain how to get to that place. Lukele was brought and said that the place was his and Doctor's home. He said Doctor would be there and that he would be able to show them where the place was. Accused 1 said they should get the police to go with them to Ermelo. They went to Ermelo in a convoy comprising a white Ford Ranger, a white BMW, and a white Vito panel van. The persons who were involved included accused 2, 3, 4, 5, and 6. Accused 5 paid for the petrol for the cars and for snacks with money given him by accused 1. Eventually they found the place where Doctor was suspected to be. The members of the police went to the place. Those persons were accused 3 and 6. They spoke to Doctor's father. They showed appointment cards and said Doctor had messed up in Johannesburg. Doctor's father said that he suspected there was a problem with Doctor. Doctor was not present. When they returned to the Mercedes, accused 3 could not open it as he was using the wrong key. Peter went to the Mercedes to see what the problem was. At this point, he would have been in close proximity to 4, who was to travel in the Mercedes. Hence, he could not, in my view, make an error concerning the identification. They returned to Money Point from Ermelo and sat there for about an hour. They reported what had happened to accused 1. Accused 2 said they should rest and meet later in the afternoon. Later they met again at Money Point office. The persons involved were accused 5, Kanyisa, Paul, accused 2 and Peter. Accused 1 was present and they all discussed the way forward. Accused 1 suggested that Lukele should be killed. Paul, Peter and accused 2 did not agree to kill Lukele and the matter was discussed. Accused 5 said they were concerned with drugs during this conversation. He, 5, was aware that he was involved in a hunt for drugs. There were complaints about the money which Peter wanted to be paid, and accused 2 was told that this would be dealt with the next day. It was agreed further that Lukele not be killed. Peter was extensively cross-examined about his statement and in relation to shortcomings in it. Peter's evidence in court was more detailed than the facts set out in the statement. He was asked as to omissions in the statement. His evidence was that he himself had edited the facts which he had provided the policeman, and that the policeman had edited the facts by not writing down everything which he had been told. He was being asked for many more details in court than he had furnished at the time he made the statement. When there are discrepancies between the evidence of a witness and his statement, it is necessary to consider whether or not these discrepancies are innocent or whether they reflect a faulty recollection or comprise deliberately given differing sets of facts. There were discrepancies between the statement which had been made and the evidence given by Peter. Peter stated that the statement, if it was inaccurate, could be inaccurate as he himself had not given as much detail in the statement as he had given in court, and as he had also not been asked about such detail, as also not everything which he had said had been written down. There were numerous differences in the detail within the evidence he gave himself as opposed to the statement he had made and with regard to other witnesses. In my view, these discrepancies do not detract from his evidence and its reliability. The evidence which he gave consisted of events which took place over a long period of time and in respect of which he gave extensive detail. He was cross-examined extensively on his cell phone records and his whereabouts from time to time over the period. There were discrepancies as to what he had said and where he had been as opposed to what the records established. In my view, these discrepancies are not material. I give as an example one of the events. It is common cause that Peter was a participant in at least certain of the events which I have found to have taken place, as I have set out earlier and for the reasons which I have set out. There is material corroboration for each of the material aspects of the evidence which he gave. As with the evidence of Paul, it matters not who went to whose house or at which precise time. What matters is that there were in fact meetings, and that during the course of these meetings the substance of what he said was in fact discussed, that the events took place as described, and that the persons who were involved were in fact involved. He was extensively cross-examined over a period of weeks as to what had happened subsequent to the events in question. In fact, the bulk of his cross-examination, as with the majority of the witnesses, concerned events subsequent to those which formed the subject matter of the charges. The relevance of the cross-examination was, it appeared to me, an attempt to establish that there was a conspiracy by the police to justify the arrest of at least accused 1 and 2. No such conspiracy was ever established, neither was there any evidence of such a conspiracy. There was lengthy cross-examination as to the involvement of one Colonel Klimba in this matter. Peter agreed that he well knew a person known as Colonel Killer Klimba. The colonel is a policeman who owns a car wash business. It was suggested to him that Klimba was involved in the dealings which he had had with the kidnappers. He denied that this was so. He explained that he often spoke to Klimba, but Klimba had nothing to do with the events. It was suggested that Klimba was a participant in the events. It was also suggested that he was the person who had influenced accused 2 to make a statement at a point in time. Whether or not he was involved in the affair is of no concern. The only reason it might be of some concern is if he was a participant in a plot to inculpate accused 1 and 2. No such plot has been established. His participation in the events is irrelevant. Even if he was a participant, the fact that he was not charged in the present matter has no impact on the facts of whether or not the offences were actually committed. Peter conceded that he was a criminal, that he had been arrested for a number of crimes, that he had previously laid a charge against Colonel Klimba, as he believed the colonel had dealt with him improperly. The colonel was a person who at a point in time accused 1 indicated may have participated in a discussion with him. Klimba and accused 1 met at a point in time, according to accused 1. This meeting long antedated the kidnapping. The evidence concerning Klimba paints him as a shadowy figure who is mentioned as entering and exiting various scenes, but who plays no visible role. The accused suggested Peter manufactured facts. There is no evidence that he did so. The facts I accept are ascertainable on well corroborated, detailed evidence given by other witnesses and the probabilities. Peter stood to gain 2 kilograms of ice crystal meth or tick, which was worth a significant amount of money, and he intended to pursue his activities in seeking to recover the drugs with a view to that end. For this reason, he did not inform the police or desist from further conduct or participation in the events. The accused made much of this criticism. In my view, it is of no consequence. The events which Peter had described in evidence were canvassed in great detail. It was put to him that there were differences between the detail described in court and the detail in the statements. For example, he had said at one time there was a squabble. In court he had said there was no squabble. He said that Klimba was met at a point in time, but that fact was omitted from the statement. He had not dealt with the fact that part of the assault took place immediately prior to the boiling of water, constituted kicking and slapping. In his evidence in chief, he had said boiling water was poured over the victim before he had gone with Lekele to phone doctor near London Road, whereas in the statement he had said it was after. In the statement he did not mention the Nissan Navara had come to one of the places where they had met, whereas in chief he had said these things. In the statement he had not said he had been to the house of Lekele the previous day, which he had said in evidence in chief. In evidence in chief he mentioned a number of persons, including policemen, had been there, whereas in the statement he did not. He had mentioned persons as working for accused one, whereas they were present as participants in the event. And he had said that he meant working in that sense. There are numerous other criticisms which have been provided to me over detailed pages of heads of argument. I do not deal with each one of them. In my view, none of the alleged conflicts is material, and none of the alleged conflicts affects the honesty and detailed evidence given by Peter. A criticism of Peter's evidence which the accused advanced is that Captain Ramahala had said that Peter had told him that he participated in kidnapping Lekele at Lekele's house. I found Ramahala to be a dishonest, devious and totally untrustworthy person in a different judgment in this case. I stand by what I said there. He, in addition to his dishonesty, was reckless and uncaring about the accuracy of his evidence. His dishonest incompetence is the fact.
We'll keep you updated on the Radovan Krejcir court case that's currently underway. But now,
this is acceptable and point to the conflict. As Peter in his evidence said that he had not been there. They seek to bolster the argument by producing the cell phone records to prove that Peter in fact was there. The cell phone record shows activity near the place where the kidnapping took place, some time prior to the kidnapping, and kidnapping his presence at Eastgate at or about the time of the kidnapping. It takes significant time to travel from the one place to the other, and it seems to me that if anything, the records support the evidence of Peter. They certainly do not establish his presence in Katlehong. In my view, this criticism, which was submitted as being one of the major points of criticism of his evidence, is unfounded. A further criticism of his evidence related to the cell phone records showing a different date for the Ermelo trip to the one he gave in evidence. It seems to me that the record is merely indicative of the fact that Peter got the date wrong. The fact that he was in Ermelo, which is the material point, was corroborated by the record showing his presence there. I accept Peter's evidence, which is cogent and accords with the probabilities. Paul Ntabela gave evidence that on the 24th June 2013, he and accused 2 had met. Accused 2 was well known to him. They were friends. He also knows accused 1. There is a conflict between the evidence of 2 and Paul as to precisely how they came to meet. This conflict is irrelevant in the light of the fact that it is common cause that accused 2 and Paul did in fact meet and did in fact contact and meet Peter and did in fact go to look for doctor. During the conversation Paul had with accused 2 said he had a problem concerning one doctor who was supposed to facilitate the export of a bag to Australia. Doctor who worked with Zimbabwe had vanished altogether with the bag of drugs he was supposed to export. Doctor was supposed to produce a slip or a waybill to show the bag had been exported and had not done so. Doctor, when confronted, had explained that the police had taken the drugs. During the conversation, accused 2 explained that a parcel had previously been sent and that to establish and that bag could and should have been sent. He further explained that Doctor had been given some Rand 70,000 as an upfront payment. On the previous day, accused 2 had suggested to Doctor that he should go to the owner and explain what had happened. Doctor had refused to go. The owner at that time was in Cape Town and would return on the Monday. Accused 2 needed Doctor to explain and or produce the bag. During the conversation, accused 2 asked Paul to help him. Paul knew someone, namely Peter. Peter, Paul, and accused 2 met. 2 explained the problem to Peter. Paul could not have known the detail unless he had been told it by accused 2. Paul also knows detail unknown to Peter and which could not have been manufactured. I've set out the portion of Paul's evidence which was not known or spoken to by Peter. The balance of Paul's evidence corroborates in the material respects the evidence of Peter. The accused. The evidence of each of the accused was a denial. Accused 1 admitted he frequented Money Point but claimed that he had been present about his own affairs and that he was not a participant in these events at all. He knew of Colonel Klimba as he had spoken to him about his apparent blackmailing of a friend of his. It is probable, in my view, that accused 1 was not just lounging about Money Point as his evidence would have it. It is much more probable that Money Point was as described by the witnesses, namely the hub of a business accused 1 was controlling. Every activity undertaken involved as a material part of it some incident at Money Point. Lukele was taken there, discussions were held there, the search was coordinated from there, attempts were made to get Doctor to go there. Accused 1 on the state's evidence was alerted to and in control of the plan to export the drug, the plan to kidnap Lukele, and the implementing of the plan. Accused 2 denied participation in any drug deal, kidnapping or assault. He admitted that he was urgently seeking Doctor at the time. He gave as a reason that he advanced Doctor money which was to be repaid. The money had been advanced to enable Doctor to purchase clothing which he would sell in a business. He stated that he stopped looking for Doctor as, at a point in time, he had been forced to pay at least some of the debt due to the person from whom he had borrowed the money, and that for that reason he had ceased looking for Doctor. This explanation is highly improbable. As I previously said, the moment a creditor pays over his own money because the debtor failed to pay him is the moment when it becomes even more important than before to obtain payment from the debtor. The much more probable reason to stop the hunt would be the realization that the subject matter of the search, namely Doctor in the bag, could not be found. Accused 2's evidence as to what he was to be repaid is also improbable. At a point in time, accused 2 claimed that he was to be repaid a certain amount. Subsequently, he claimed he was to be paid that amount and a share in the business. He also claimed that the full amount was fully due, owing and payable at that point in time. This could not be unless all the clothes which had been bought with the money had been sold. It is improbable that this could have happened as a unit. It is much more likely a business over the period of time would generate funding, and that as and when it did, the debtor would pay the creditor. At a point in time, accused 2 seems to indicate that the urgency was related to the salary Doctor would receive at or about that time. This suggestion is highly improbable, having regard to the small salary and the large amount accused 2 was seeking to recover. The claim of 2 is in direct conflict with the evidence of the state witnesses. It is improbable, having regard to the scope of the search, the number of people employed in it, the amount of money changing hands, and the urgency. It appears to me that accused 2's evidence is false. The search concerned attempting to recover drugs and the missing courier. The search included the kidnapping and assault of Lekele. There is no explanation on the evidence for accused number 2 for the kidnapping and assault on Lekele. The probable reason for the kidnapping and assault is, as set out before, to flush out doctor and recover the drugs. Accused 3 is a member of the South African Police. On the 25th June 2013, he had 3 phones which he kept with him continuously day and night. He was investigating and was on duty. He used a Mazda 6, a police vehicle allocated to him. He was investigating corruption of traffic officers on the East Rand. On that day, he was nowhere close to Katlehong, which is the place where Lekele was kidnapped. He was nowhere near the Sasol garage at or about the time the meeting took place prior to the kidnapping. He denied being at any of the other places. He was involved in none of the offences, according to him. He knew about a bag of drugs in the abstract as he had heard about it. He had no personal knowledge of these things. Accused 4 and 6 are his colleagues. He knew neither accused 1, nor 2, nor 5. In 2013, Themba had asked him to set up a meeting with 1 and asked him if he knew accused 1. He did not set up the meeting as he did not know him. He later said in conflict with his earlier evidence that Themba had phoned him and asked only if he knew 1. He had not asked him to set a meeting. He knew Peter. They had from time to time lent each other money. On the afternoon, 25 June 2013, he was at Bradford Road and at or near Money Point. The records show the vehicle parked near Bradford Road and stationary there for a period of time, moving a short distance and stationary again. Accused 3 said he was not inside Money Point. He was at the taxi rank about 100 meters from Money Point. He said that he'd worked together with accused 4 in the same group and that their vehicle records would show them together at OR Tambo at the airport. At that time, they were working on a complaint involving rifles, RDP houses, and drugs. He previously had said that the work with which he was involved was corrupt traffic officials. During the course of the trial, it was put by accused 3 that the vehicle he drove was allocated to him for his exclusive use. When he gave evidence, accused 3 modified the version to cope with the conflict in his evidence that he did not have exclusive use of the vehicle by saying that the person with whom he shared had come after the vehicle had originally been allocated to him exclusively. This point might appear insignificant, but it is material as the sole use of the vehicle founds his alibi defense. Accused 3 referred to vehicle records as establishing he was not at Lekele's home at the time of the kidnapping. The records show the vehicle in which he claimed to be, inter alia circling in the immediate vicinity of the airport and at a time stopping near accused 4's vehicle. The evidence of accused 3 is flawed in material respects concerning inter alia his exclusive use of the motor car, why he was with accused 4 on the day, and in particular what he was doing in the afternoon he was at or near Money Point. The probabilities are that the vehicle used by 3 would not drive aimlessly around the airport as it seems to have done. The investigation, whether it involved traffic officers, rifles, RDP houses and other corruption, including drugs, remain unlinked to the movement of the vehicles and the movement of 3 on the day. It appears to me that 3 and 4 have orchestrated an alibi through the use of their vehicle records. The value of the vehicle records would be well known to both the accused 3 and 4 to establish their whereabouts. The fact that any particular cell phone records demonstrate accused 3 as being at any particular place on any particular day do not independently of his evidence establish his whereabouts. He had a number of phones, shared the vehicle, and in my view has no cogent explanation for the manner in which the vehicle was driven at the relevant time. In addition, Accused 3 was identified as being at the garage at at the Sasol garage at Money Point when Lukele was assaulted, at Bethel at the filling station, and at Ermelo when they were looking for Doctor by Peter. Paul identified accused 3 as being at Money Point when Lukele was assaulted, and at Ermelo when they were looking for Doctor. Accused 3 himself put himself at or near Money Point in the afternoon, at or about the time of the kidnapping. The coordinates show, according to what was put to him, that he was on the premises. These records are apparently accurate, according to the expert, to within 5 meters. He was also seen at Money Point and admittedly went there. He claims he went on business. In my view, it is not a coincidence that accused 3 is linked to events at Money Point by the witnesses, and his admission that he was there on occasion, but for a different reason in my view. Accused 4. The evidence of accused 4 was that over the period of the kidnapping he was working with the organised crime unit, and in particular that on the 25th June 2013 he was working with 3 on the same project. He was involved in the observation concerning a crime involving drugs. He said he was working with 3 but was not with him continuously. He specialized only in drugs. That was his main concern, whereas 3 was a coordinator of the other matters which were being investigated. This is in conflict with his evidence given at a point in time that 3 and 4 were working together on a number of matters. Accused 3 did not isolate any particular matter as being within the domain of 4. He explained he was at OR Tambo on 25 June 2013 for observation. He also had his own purpose, which was to fetch a plane ticket for his child who was leaving the next day for Durban. Subsequently, it became clear that he was fetching not only a ticket for his son but for other people. There was also confusion in his evidence relating to when he was supposed to travel and when precisely the travel would take place in relation to the fetching of the ticket. He was unable to explain why details which had been given by the state witnesses, such as that he was a policeman, had worked with accused 4, had been at Money Point at or about the time when his records show him to be there. In addition, accused 4 put it to Captain Ramahala that the reason 4 had been to the airport was to purchase a ticket, as if that was the only reason to go there. It was not put that he was there about the business together, or there about police business together with 3. I do not accept the evidence of 4 and do not accept that he was in exclusive possession of the vehicle or in possession of it at all at the time that he was identified as being one of the kidnappers at Lukele's house. I further do not accept that he was not present in Ermelo. It was submitted there could have been an error made by Lukele in identifying accused 4, whose name is Jeff, in that Jeff was the person who had been at the property earlier in the day, bracket, Peter, close bracket, and was not the current accused 4, Jeff. There is no evidence that the witness was in any way confronted with the names of the persons he identified, or that he identified any person on the basis of a name. He identified on the basis of what he saw. He dealt with the 6 attackers at his home for some time. He was in their presence for some time prior to being manhandled and bundled into the car. In the later statement he made, he said he would be able to identify them, although he did not give a description. The fact that he did not give a description is indicative of poor police investigation rather than his inability to give one. In an affidavit dated November 2013, Lukele said that his eyes were closed so he might not be able to identify his attackers. This is the only very hesitant indication that he could not identify them, and is directly in conflict with his earlier statements that he was able to, and his subsequent conduct in actually identifying them. Accused 4 produced documentation reflecting he'd been in possession of the motor vehicle issued him by SABC. This was presented as an alibi based on a finding that he was in fact in possession of car and cell phone. They were similar in nature to those produced by 3. For quite some time over the relevant period, the 2 accused were driving seemingly aimlessly around the airport. Both accused at all times are aware of the tracking capabilities of cell phones and of the cars which they drive, which are fitted with extremely accurate tracking devices. It is inconceivable that they would take those cars with them when they wanted to perform activities where they did not wish to leave an electronic trail. It is much more likely they would use them to create a fictitious alibi. I do not accept Accused 4's version. Accused 5's evidence was a blunt denial of what had been said of him by the state witnesses. He said his name was Mia and that he had never been known as Zulu, Zuluboy or Sbu. He raised as an issue that he may have been implicated because he had fallen out with one Klimba. It is apparent from the facts which I've set out previously that he was identified positively as being a participant in numerous of the events and by numerous witnesses. His explanation is not only incredible, it appears to me to be untrue. There is simply no indication of any accused being substituted for any participant. The detail concerning his identification is detailed in time, place, and event. He is a person involved in the taxi industry in which people are killed for little money. He claimed never to have experienced this. It is a well-known feature of this country that the taxi industry is regularly involved in violence. The motive of Peter and Paul to implicate him appears to me to be non-existent. Peter identified accused 5 at Money Point, where Lukele was assaulted at the safe house on 25 June 2013, as being with him hunting in Davidton, as being with him at Money Point prior to the Ermelo Point, and at Money Point when they returned. Peter also identified him as being the person who took Lukele to phone Doctor, and as the person who spoke to Doctor. This evidence is corroborated by a doctor. He was also one of the people who was opposed to the killing of Lukele. Paul identified accused 5 at Money Point prior to the Ermelo trip. Accused 5 fetched Lukele from the safe house. During the Ermelo trip, he was identified as the person who had paid for the petrol and the snacks with the money he got from accused 1. Paul well knew accused 5. Accused 6. Accused 6 is a member of the South African police. Similarly, his evidence was a blunt denial. He conceded that he works together with accused 3 and 4 at the same office. At the time of the events, he was on leave. Accused 6 was similarly identified as previously set out by numerous witnesses whose evidence was reliable. He was identified as being at Money Point when Lukele was assaulted and at the Bethel filling station on the way to Ermelo. Paul identified 6 as being at Money Point before they left on the Ermelo trip and also at Ermelo. All the accused were identified at various points in the events by various witnesses. All save for accused 4 were present at Lukele's assault at Money Point. One or more, all of the accused were present at various other points. The witnesses who gave evidence of the trip to Ermelo identified which accused was present at which particular time. There is evidence which inherently contains the assertion that those who had left for Ermelo returned. The fact that different witnesses saw different accused at different times does not mean they were not participants throughout the Ermelo incident. The witnesses who gave evidence of occurrences where only a few of the accused were present corroborated each other as to what had happened. All the events spanned more than a few minutes each. There was ample opportunity to observe in each case. The sightings occurred over several days, and the witnesses had both time and opportunity to recollect and reinforce the identification of each of the accused. In addition, certain of the accused were well known to certain of the witnesses. In my view, the identification of each of the accused is reliable and supported by the probabilities. The identification of ice, tick, crystal meth as methamphetamine. Count 1 charges the 6 accused with dealing in an undesirable dependence-producing substance in breach of Section 5B of Act 140 of 1992, in that the accused dealt in methamphetamine, commonly referred to as crystal meth stroke ice stroke tick. It is an element of the charge, and the state is required to establish that the accused dealt in 25 plastic bags containing that substance. The first issue is to be resolved is whether the state established that the substance allegedly dealt in was the substance defined in the Act, namely methamphetamine. No expert evidence was called. The evidence was that accused 2 referred to the contents of the bag as being drugs. Paul told Peter, in the presence of 2, that 2 had also told him that what had been lost was 25 kilograms of crystal meth. Accused 2 agreed to pay Peter 2 kilograms of tick if the bag containing all the drugs was recovered. Paul said that accused 2 had said that he had a problem about a bag containing ice, which was supposed to be sent to Australia. Accused 2 is the source of the information of what the bag contained. He knew what was inside it. Doctor referred to the substance as ice. Doctor did not know what was in the bag, which was sent on the dummy run, but was told by accused 2 that it was a drug. Accused 2 gave Doctor the bag containing the 25 parcels. Doctor thought that the contents were ice, as in frozen water, as when he was told to take the bag with him, his response was, "What if it melts while in my possession?" Doctor's description of the contents of the parcels as having properties similar to the properties of ice is indicative of the fact that he was told that in fact they contained ice. He, Doctor, clearly had no idea of what ice was and assumed the reference to be frozen water. The fact that this suggestion to him led him to believe that the properties of the packets were frozen water is indicative of the power of the suggestion which had been made to him. In my view, the state proved that it was stated that accused 2 on various occasions stated that the parcels contained crystal meth, tick and ice. Additional evidence that the bag in fact contained drugs is found in the elaborate and furtive process to export the bag, the value of its contents, and in the nature and the cost of the search to recover the bag when it was lost. This was a hunt on a large scale, a hunt at all costs to recover something extremely valuable. The statement of accused 2 is not admissible against the other accused, but is one of the facts setting the matrix, and what he stated is obviously admissible against him. In my view, the bag was proven beyond reasonable doubt to contain a drug known as crystal meth, tick and ice. The question remains whether that evidence establishes that its contents were methamphetamine. I consulted a number of online dictionaries, including the Oxford Dictionaries Online and the Concise Oxford Dictionary. The Concise Oxford Dictionary, 10th edition, published 2001, defines meth, brackets, also crystal meth, close bracket, as being methamphetamine. The Oxford Dictionaries Online describes crystal meth as being methamphetamine. The Memedic's Online Dictionary describes crystal meth as a methamphetamine derivative used in the form of a crystalline hydrochloride. Its source is given as a crystal methamphetamine or methamphetamine hydrochloride. The synonyms for the substance include crystal, glass, ice, and meth. The Memedic's Dictionary, which defines crystal meth as being crystal methamphetamine, describes it as a concentrated and highly potent form of methamphetamine with dangerous side effects. A number of other dictionaries which are referred to online describe methamphetamine, ice, tick, crystal meth, crystal, all as synonyms for methamphetamine. In my view, the English language defines the name of all the references, namely crystal meth, tick, or ice, as meaning methamphetamine. The use of the language by accused 2, being the colloquial usage of methamphetamine, constitutes an admission by him and a reference by him to the prohibited drug methamphetamine. In the present matter, the drug forming the subject matter of the charge was sold by doctor and is irrecoverable. It is impossible to check and analyze the substance contained within the plastic bags. The only source of the contents of the bags can be the ipso dixit of 2 to the various slang usages meaning methamphetamine. The use of the language by 2 of the abbreviation and slang having the same meaning as the word contained within the statute is, in my view, a reference to the word contained within the statute and the substance defined by that word, namely the prohibited substance. Accordingly, accused 2, on the evidence provided, accordingly, as far as accused 2 is concerned, on the evidence provided, knew and described the contents of the bag as being methamphetamine, the illegal drug which I found the contents of the bag to be. Each of the 25 bags was worth approximately Rand 300,000, and the total consignment was worth of the order of Rand 7.5 million on the evidence before me. The extent of the steps taken to recover the drugs demonstrates the employment of a significant number of people and a significant degree of urgency. These steps must have been expensive. Peter would have been paid of the order of Rand 600,000 had the drug been recovered. The lengths to which the persons seeking to recover the drug were prepared to go also indicates the value of the substance and that it is a drug. It is highly improbable that for a relatively insignificant amount, Lekele would have been captured, tortured, and held hostage for several days. In addition, the resources which were employed in the attempts to recover the bag, there was also expenses which were incurred. For example, traveling to Ermelo, hiring the various policemen who participated in the hunt, traveling to the airport, to Katlehong, and the various other places which almost on a continuous basis, which almost on a continuous period over some days was undertaken by a significant number of people, including in particular accused 2. In my view, it is established beyond doubt that the bag contained methamphetamine. Section 256 of the Criminal Procedure Act makes it competent if the evidence proves an attempt to convict of an attempt. Section 256 provides, if the evidence in criminal proceedings does not prove the commission of the offence charged, but proves an attempt to commit the offence, or an attempt to commit any other offence of which an accused may be convicted on the offence charge, the accused may be found guilty of an attempt to commit that offence, or as the case may be, such other offence. This section makes it competent for an accused who participates in a crime to be convicted of an attempt if the facts are appropriately proven. The offence charged is dealing in a prohibited substance. The offence charged an element of the offence involves not just the existence of a state of affairs, but proof that the affairs concern the prohibited substance. The definition section of the Act provides that dealing is constituted by performing any act in connection with the transshipment, importation, cultivation, collection, manufacture, supply, prescription, administration, sale, transmission, or exportation of the drug. And the offence which is contained in Section 5b provides that no person shall deal in any dependence-producing substance. In this case, accused 2 and accused 1 were involved with the arrangements for an exportation of the drugs contained in the bag. Accused 2 was the person who made arrangements with the courier and who implemented the plan. Accused 1, beyond doubt, is the mastermind who only appears as and when required. Accused 1 was intimately involved and in control of all the events described by the state witnesses. Accused 1 and 2 were also instrumental in attempting to recover the bag by way of recovery of the person in whose possession they had left the bag. The knowledge of accused 2 was the knowledge of accused 1. Accused 2 and accused 1 both knew that drugs were inside the bag. Accused 2 knew the drugs were methamphetamine. Accused 1, according to what accused 2 said, would also have known this. The extracurrial statements of accused 2 concerning the identification of the drug as crystal meth, tick or ice are inadmissible, however, against accused 1. Accused 1's knowledge is limited on the admissible evidence before me only to the fact that the bags contained a prohibited drug. In my view, the knowledge of accused 1 extended to any one of the prohibited drugs listed in the Act, and in fact any one of the drugs listed in the Act. Hence, accused 1 attempted to deal in methamphetamine as the state proved that what was in the bag was in fact methamphetamine. What the state failed to prove, as against accused 1, was his knowledge as to the contents of the bag. The provisions of Section 256 allow a conviction of an attempt. In State v. Ndlovu 1982, 2 SA 202, Nestat J held at 205 that a conviction of attempt was competent on a similar provision. In the present case, accused 1 was attempting to commit what on the evidence before me is impossible, namely the export and recovery of a prohibited substance which has not been proven as against him to be the particular one alleged. Hence, on my analysis, accused 2 is guilty of count 1, while accused 1 is guilty only of an attempt to commit the offence in count 1. Accused 3, 4, 5, 6 and count 1. It remains to deal with the involvement of accused 3, 4, 5 and 6. It was submitted that the evidence did not establish beyond reasonable doubt that they knew the person they were hunting was being hunted because of his possession of the bag of drugs. The bag and doctor were freely discussed among all the accused. There is, save in respect of accused 5, no evidence actually identifying the contents to the accused. In respect of 3, 4 and 6, there is no reliable evidence they knew the bag contained drugs. The position of 5 is different. At the meeting where the killing of Lukele was discussed, accused 5 and others opposed his murder. At that time, accused 5 said they should not kill him and that they were seeking drugs worth millions. Hence, he knew the bag contained drugs. There is no evidence that he knew which specific drug was within the bag. However, on the same reasoning as applicable to accused 1, he is guilty of an attempt. Identity generally. The witnesses who identified the accused were able to, in addition to making the identification, correctly refer to numerous facts about each witness. The witnesses were able to identify the policeman as such, money point as the hub of activity, the different roles each accused played, features of each individual accused, and so on. The fact that the corroboration in detail exists strengthens the probabilities that the identification is accurate. On the aforegoing analysis, it appears to me accordingly that insofar as count 1 is concerned, accused 2 is guilty on the main count, while accused 1 and 5 are guilty only of an attempt. In respect of count 2, It was established in respect of all the accused they participated from time to time. On count 3, there was evidence in relation to accused 1, 2, 3, 5 and 6, but not accused 4. In my view, the evidence given by the accused is not reasonably possibly true and cannot be so in the light of findings which I've made with regard to facts which underpin whether or not the evidence can be reasonably possibly true. The SAPS. The accused submitted that Lekele had made a conscious decision not to pursue any charge, and hence the earlier charge had not been prosecuted. These submissions arose out of the fact that a docket had been opened pursuant to a charge being laid by Noble at the time prior to the release of Lekele. The police, according to the investigation diary, had taken steps to investigate the matter, concluding that the registration number given by Noble and the type of vehicle were incorrect. On 3rd July 2013, the police discovered that Lekele was at home having been released. Lekele told him, according to the docket, that he had been released because persons who had kidnapped him were looking for his brother, not him. There is an entry contained within the docket dated 8th July 2013 stating that the docket was closed as being false. Notwithstanding the clear evidence before the SAPS as to the facts concerning the kidnapping of Lekele, no further steps were taken by them. The next step in the investigation was the assignment of the case to the investigating officer, Captain Ramahala, by General Munu. The instruction Captain Ramahala received was to trace and arrest the suspects. At a point in time, he received the old docket from General Munu. This docket appears to have been made available at some time after the investigating officer had commenced the investigation. It is apparent that the investigation was commenced not in consequence of any initiation of it by Lekele, but from some other source. It became common cause that the fresh investigation had commenced on the instruction or emanated from the National Task Team in Pretoria. It appears as if the police had discovered the existence of what had happened to Lekele and, pursuant to an instruction to investigate further, did so. It was submitted that the instruction given was to get accused 1, and that in the course of doing so, the police behaved improperly in the investigation by creating and or tampering with and or failing to obtain evidence. There is no evidence that the police in any way were instructed to falsely implicate any of the accused, or that the police in fact did so. There is no evidence of any conspiracy on the part of the police to implicate any of the accused or modify the evidence. The evidence of the kidnapping, assault and drug deal are established independently by the witness to the events. Accused 1 and 2 have been found by me to be party to those events independently of any police action. The other accused, 3, 4, 5 and 6, are identified by detailed evidence corroborated in material respects. In my view, not only is there no evidence of tampering, it is improbable that there was tampering with the evidence. The investigation of the police was poor. There were sources of information which could have been collected and used. There were leads which were not followed, and there was objective evidence which was not obtained. The fact that the investigation was poor and some evidence not obtained in no way leads to the inference being capable of being drawn that the evidence was in any way tampered with, or that in any way any of the witnesses were directed as to who should be implicated. The submission is made that as the police knew who the suspects were, the identity of the suspects could have been created by the police with a view to them being implicated. There is simply no evidence of this conduct. The submission was made that there were, throughout the occurrence of the events during June 2013, numerous phone calls made to and from several witnesses and one Colonel Klimba. The cell phone records of the various witnesses evidence frequent phone calls being made from time to time over the period. The explanation of the witnesses was that the phone calls were innocently made and had nothing to do with the case. Even assuming the phone calls were related to the case, the fact that they were being made in no way means that the facts were being invented or manipulated, or that the accused were being substituted for perpetrators. One does not know if Klimba, in the course of his involvement by way of phone, was evidence gathering for the SAPS or whether he was a rogue operative. Whichever one of the two it was does not have any effect upon the facts before me, and his conduct, in my view, on the evidence before me does not amount to any change or tampering with the evidence placed before me by the witnesses. The rhetorical question was put to me as to how the police could know that persons not identified in affidavits were the physical persons who subsequently became the accused. The answer of the investigating officer is that there were informers and that the witnesses were reliable. Before me, the witnesses gave evidence, and in my view, that comment made by the investigating officer as to the reliability is accurate. The submission was made that the trial was unfair in that evidence which had not been collected, in that certain evidence had not been collected, and, for example, an identity parade had not been held. The submission was made that had an identity parade been held, the accused would have been vindicated, as witnesses would not have identified them. Had video recordings which could have been collected, the accused would have been vindicated, as their presence would not be visible on the video. In my view, these are all highly speculative submissions founded upon the premise that the accused were not participants. All of the witnesses who gave evidence as to the identity of the accused, in my view, attempted of their own accord to describe and relate how each particular accused was involved and why that accused was involved. It was submitted that certain of the evidence was taken unconstitutionally, in that, for example, a witness had been lied to as to the reason why he was being taken to the police station. The answer to this is that there may well have been lies about why the witness was being taken to the police station. However, the witness voluntarily made a statement there and subsequently voluntarily testified. In my view, the concept of fairness in a trial was in no way eroded in this case before me. It was submitted that several of the records establishing the whereabouts of the cell phone of the investigating officer and others demonstrated that what had been said in evidence was inaccurate. The criticism is factually correct. It must be remembered that the kidnapping endured over a period of time. The events took place over an extended period of time. In addition, the persons hunting the accused and the bag of drugs were under pressure to perform the hunt. They appeared to me to have done a large number of things in a short space of time. In these circumstances, it is not unreasonable for a witness to remember certain events in an inaccurate order or in a slightly inaccurate way. The question is not whether there is an inaccuracy. The question is whether or not the reliability of the evidence remains intact, notwithstanding the inaccuracy. In my view, the witnesses who gave evidence before me attempted as best they could to give detailed evidence over an extended, relating to events which took place over an extended period of time, and accurately and materially describe those events. One would expect witnesses dealing with extensive facts and over an extensive period of time to inaccurately recall minor details or to jumble the order on occasion. In my view, the true result of the police's improper and inadequate investigation, for so it was in this case, is that it put the state case at risk. The state case was dependent upon an unlawfully obtained confession which I excluded in evidence, and such witnesses as the state was able to marshal. By the nature of the events, many of those witnesses fall into the category of accomplice. I'm conscious of the fact that accomplice evidence can be and often is easily manipulated. An accomplice can easily substitute one person for another while maintaining the true set of facts. The accomplices in this case are accomplices in respect of different facets of the case which overlapped in extent. Some were hunters, some were drug dealers. There is sufficiently objectively accurate evidence and factually corroborated evidence for their evidence to be accepted, notwithstanding their particular relationship to the persons involved. The overlapping portions of the case are insightful, as the different witnesses to different events would not in detail, as they did, give the same evidence unless it was true. I've not dealt with each of the submissions made and each factual discrepancy allegedly existing, as those submissions ran into hundreds of pages. I've dealt with what I believe to be the pertinent issues and the probabilities, namely what happened, who probably caused what happened to happen. Those inquiries, which I believe to be the proper ones, encompass a relatively small portion of voluminous evidence and extensive cross-examination into minutiae. I allowed extensive cross-examination, although I at the time believed that the cross-examiner was merely milling grains of sand on the beach. After the milling of all these grains of sand, the picture of a beach remained the same. It was still sand on the beach. The accused, however, was allowed fully to exercise all of their rights of obtaining documents and investigating each aspect as deeply as the laws of evidence permitted. The fact that after this intensive attack upon the witnesses' evidence, the witnesses remained intact is testimony to the fact that they were telling the truth. I refused an application for the discharge of the accused. I said I would give the reasons later. The reasons which I've set out above are those reasons. It follows that, in my view, as far as count 1 is concerned, accused 2 should be found guilty of the main count, accused 1 and 5 guilty of an attempt. In respect of count 2, in my view, all the accused before me should be found guilty, and in respect of count 3, accused 1, 2, 3, 5 and 6 guilty. It remains only to deal with the Section 204 witnesses. The witnesses who were warned in terms of Section 204 gave their evidence acceptably and are entitled to the indemnity the section permits me to give them. It is a matter of sorrow that persons who were involved in reprehensible conduct walk free. The law recognizes, however, that society must sometimes sacrifice its right to convict wrongdoers in the interest of convicting others. There was no easy way for the state to obtain a conviction otherwise by using witnesses who were complicit in the events. It is apparent from what I have said, and it is my view, that the following is an appropriate order, and I convict the accused as follows. 1. Count 1. Accused 2 guilty, main count. Accused 1 and 5 guilty of attempted contravention of main count. Accused 3, 4 and 6 acquitted, main count. 2. Count 2. Accused 1, 2, 3, 4, 5 and 6 guilty. 3. Count 3. Accused 1, 2, 3, 5 and 6 guilty. Accused 4 guilty of common assault. 4. Section 204 witnesses. 4.1. The witnesses mentioned below are indemnified from any possible prosecution arising out of the events specified. 4.1.1. Peter Vusi Msimang is indemnified from any possible prosecution in relation to counts 1 and 2 of the indictment. 4.1.2. Paul Mtabela is indemnified from any possible prosecution in relation to counts 1 and 2 of the indictment. 4.1.3. Becky Sizwe Dr. Nkosi is indemnified from any possible prosecution in relation to count 1 of the indictment. 4.1.4. Becky Zita Subaba Kumalo is indemnified from any possible prosecution in relation to count 1 of the indictment. Court adjourns.
So now what's going to happen? There's no sentence or nothing. Bail is still extended.
Yeah.